The Honorable Court of Criminal Appeals is now in session.
Welcome to the May docket of the Court of Criminal Appeals, Western Division, sitting in Jackson. On the panel today is our presiding judge, John Everett Williams from Huntington. He is not presiding because of various technical difficulties and power outages that have arisen, and it's impacted his audio. And in that regard, we really appreciate all the work that our clerk's office and our technical experts have done to make this happen. It was sort of questionable there for a while. Also on the panel is Judge Jill Ayers. Judge Ayers was recently appointed to this court by our governor, and before that she served with distinction as a circuit court judge in Montgomery and Robertson County, so we're especially glad to have her with us on the panel today. I'm Kelly Thomas, and I'm from Maryville. We have our usual 20 minutes per side. If the appellant wants to reserve some rebuttal time, just let me know when you begin your argument, and then I will let you know when you get close to your rebuttal time. If there are no more preliminary matters, call the case, please.
State of Tennessee versus Maurice Ricky Blocker.
All right, on behalf of the appellant.
Good morning, Your Honors. My name is Janet Good, and I have the privilege of representing Mr. Maurice Blocker in this appeal of the denial of post-conviction relief, and I want to reserve 5 minutes of rebuttal time.
You may. Go ahead.
All right. Thank you. This case arises out of Shelby County. Mr. Blocker was convicted of first-degree murder and theft of property following the stabbing death of his girlfriend, Letitia Bodie, and his alleged flight in a stolen truck. The core issue in this case was whether or not the state proved, the core issue at trial in this case was whether or not the state proved beyond a reasonable doubt that Mr. Blocker acted with premeditation, and that is whether or not the state was able to prove first-degree murder. Mr. Blocker has never denied his responsibility for the death of Letitia Bodie. What he has consistently denied and continues to deny is that he acted with the culpable mental state for first-degree murder. The element of premeditation simply wasn't present, but for the ineffective assistance of counsel, of his trial and appellate counsel, Mr. Blocker would not have been convicted, nor would his conviction have been sustained on appeal. I will rely on my briefs for a full explication of these issues, and will focus mainly on the per se ineffective assistance of counsel in announcing that Mr. Blocker pled guilty to theft without Mr. Blocker's consent. As a result of the ineffective assistance of his counsel, Mr. Blocker was deprived of a fundamentally fair trial. At trial, Mr. Blocker put on 2 expert witnesses to testify to his drug addiction. The experts testified that Mr. Blocker has brain damage as a result of his years-long alcohol and drug addiction. Dr. Walker determined that Mr. Blocker has an IQ of 75 and was unable to think and reason as effectively as the average person as a result. Dr. Walker also testified that Mr. Blocker was unable to make decisions effectively or consider the consequences of his behavior due to the amount of cocaine and alcohol he had consumed in the days leading up to Ms. Bodie's death, and for his total lack of sleep in the 4 days prior to her death. Dr. Walker testified that Mr. Blocker would have been unable to form intent or to premeditate the murder. He said that Mr. Blocker acted out of passion when he got angry and just acted impulsively. This expert testimony was prejudicially undermined by the deficiencies in trial counsel's performance. But for those deficiencies, the outcome of the trial would have been different. So first, entering a guilty plea to theft without consulting Mr. Blocker violated his 5th, 6th, and 14th Amendment rights. This is per se ineffective assistance of counsel requiring reversal of his conviction. The evidence in the post-conviction record preponderates against the post-conviction court's findings of fact. Trial counsel Rob Gowan gave conflicting testimony during the post-conviction hearing. First, he testified that he thought the defense team discussed pleading guilty to the theft of property with Mr. Blocker, but that, quote, he could be wrong. On cross-examination, he then said that he did in fact discuss pleading guilty with Mr. Blocker on the morning of trial. He never actually testified that Mr. Blocker agreed to plead guilty. And the closest he got was that he testified that, quote, I don't believe for 1 minute that he didn't have advance notice of this. Mr. Blocker is entitled to more than advance notice. In order for a guilty plea to be constitutionally valid, the record must demonstrate that a defendant knowingly and voluntarily waived the following federal constitutional rights: privilege against self-incrimination, the right to a trial by jury, and the right to confrontation. Mr. Blocker testified that his trial counsel did not consult him and that he never consented to pleading guilty to the theft charge. And that testimony was supported by the testimony of Amy Main. Ms. Main was co-counsel at trial and testified that she did not remember discussing entering a guilty plea with Mr. Blocker. Instead, she testified that, quote, normally I would not want to plead that out before the murder charge because I'd be afraid that it would affect the case. So I think we just left that open. And it did affect the case. So how did it prejudice Mr. Blocker? After all, this was a plea to theft, which is a minor crime in light of the first-degree murder charge that he ultimately was convicted of. What did the plea look like? I mean, what happened in the courtroom when the defendant was sitting there? So I think it was, in front of the jury, how does the defendant plead? And defense counsel announced he pleads guilty to not guilty to count one, but guilty to the second count. And Mr. Blocker remained silent. Okay, but this was when the trial started at the very beginning. Yes. Okay, all right. Yep. So first, Mr. Blocker's constitutional right to decide whether or not to plead guilty to any charge cannot be overstated. He did not consent to pleading guilty to theft, and it was per se ineffective assistance of counsel. But secondly, to the extent that this court considers the state's argument that this was a trial strategy, and as such did not amount to ineffective assistance of counsel, that argument doesn't make sense. So the state argued in its brief that just because the trial strategy was unsuccessful does not mean that counsel was ineffective. And the thinking behind the strategy was to gain credibility with the jury. So we'll plead guilty to the theft because he's guilty of the theft, but he's not pleading guilty to first-degree murder. But you can't gain credibility for accepting responsibility for a charge that had very little supporting evidence. The theft charge in this case had tenuous evidence supporting it at best. And defense counsel said as much in the motion for acquittal when he said that he didn't think there was any proof to even send it to the jury. And and as a result, he didn't even cross-examine witnesses when they were talking about this theft, testifying about the theft. So to gain credibility with the jury, the charge would have had to have been supported by evidence. And the evidence that was presented was that the owner of the vehicle described an African-American man as having stolen his truck. That's it. That was the only description. And while there was testimony at trial that Miss Greer, Katie Greer, whose house this incident occurred at, saw Mr. Blocker leave her house in a truck with a license plate matching the stolen vehicle, nothing else connects Mr. Blocker to the truck or its theft. The vehicle was later found in Little Rock, Arkansas, but it had a different license plate. Therefore, it's impossible to tell whether the vehicle that Mr. Blocker was seen driving simply had the stolen truck's license plate on it, or whether in fact it was the stolen truck. And no evidence points to Mr. Blocker ever being in Little Rock. Mr. Blocker's EBT card was used in Chicago, Illinois, shortly after Miss Bodie's death, and then later in Los Angeles, California, which is where he was detained. And so finally, the state's argument about this being a trial strategy is explicitly controverted in case law. In Florida versus Nixon in 2004, the Supreme Court wrote, and then this is a quote, while a guilty plea may be tactically advantageous for the defendant, the plea is not simply a strategic choice. It is itself a conviction, and the high stakes for the defendant require the utmost solicitude. Accordingly, counsel lacks authority to consent to a guilty plea on a client's behalf. Moreover, a defendant's tacit acquiescence in the decision to plead is insufficient to render the plea valid. The prejudice associated with defense counsel announcing that Mr. Blocker pled guilty to theft without Mr. Blocker's consent was compounded by the failure to object to the trial court's error when it gave its jury instructions. And furthermore, that failure to object to the trial court's jury instruction error prevented the issue from being preserved for appeal. So the trial court erred when it instructed the jury that Mr. Blocker had pleaded not guilty to count one and had pled guilty to the second, to the theft charge, but subsequently submitted both charges to the jury for their consideration. I think, again, the elephant in the room, the big question is, well, what is the prejudice? And the state in its brief once again referred to this as a strategy and argued that just because it was an unsuccessful trial strategy does not mean that counsel was ineffective. The prejudice is that by admitting guilt to a theft charge for which there was almost no evidence gives the jury the impression that that is all that is required for conviction. Pleading guilty to the theft also weakened Mr. Blocker's defense against premeditation. Admitting to fleeing in a stolen truck prejudicially weakens his argument that it wasn't a premeditated crime. It prejudicially infects the jury's thinking about the merits and the weight of Mr. Blocker's defense. And in turn, it prejudicially weakens his argument that it was not a premeditated and knowing murder. It was ineffective assistance of counsel to announce that Mr. Blocker pled guilty to theft without his consent, and to fail to object when the trial court instructed the jury that Mr. Blocker had pled guilty, but charging them nonetheless to deliberate on that count. The three other areas of ineffective assistance of counsel that I briefed worked in tandem to prejudicially weaken Mr. Blocker's defense. And those areas include a failure to object to several instances of hearsay, a failure to seek a jury out hearing or to request a mistrial when a juror remembered in the midst of jury deliberations Mr. Blocker's face from television 2 years prior and had failed to disclose that in voir dire, and failure to impeach Katie Greer, who was a key state witness with her prior inconsistent statement. As I said earlier, it was at Ms. Greer's house that this incident occurred, and she testified at trial that Mr. Blocker said words to the effect of "done now, bitch," after stabbing Letitia Bodie. This statement goes to establishing premeditation, and the failure to properly impeach the statement with the witness's prior statements to the police, in which she never testified, she never told them that that Mr. Blocker had said that, harmed Mr. Blocker's defense. At the post-conviction hearing, the state, said as much as to the prejudice of that statement. The prosecutor said that premeditation was established when the victim was on her knees begging for her life, and he stabs her and then makes the comment, "Now you can go, bitch. Now you can leave the house." Trial counsel, defense trial counsel, Mr. Gowan testified that he didn't belabor the point when cross-examining the witness and his initial sort of attempt to impeach her because he didn't want to further highlight the testimony. And again, the state argued that this is trial strategy. And although Tennessee courts have consistently given deference to matters of strategy and tactical choices of trial counsel, that only applies if the choices are informed ones based on adequate preparation. Trial court testified at the post-conviction hearing that he, quote, wasn't sure if he had what was needed to impeach the witness, and admitted that the statement definitely didn't help him when asked if the statement had prejudiced Mr. Blocker. So that, not being sure if he had what he needed is inadequate preparation that prejudicially impacted the outcome of the trial. Finally, Mr. Blocker's counsel was also prejudicially ineffective on appeal. The only issue raised on direct appeal was sufficiency of the evidence. Failure to appeal the trial court's error when giving jury instructions was prejudicial error, leading to Mr. Blocker's conviction being sustained on appeal. This court's opinion said that it was cautioning the trial court that its decision to inform the jury of a defendant's partial or incomplete guilty plea to a charge before submitting that same charge to the jury is fraught with peril, and we discourage this practice in the future. However, because neither party raises this issue on appeal, we will not consider it further. So by its, in its decision, this court recognized that the error was prejudicial, but declined to take it up because appellate counsel had failed in his duty to raise it before the court. And that's a textbook definition of ineffective assistance of counsel. As a result of these numerous areas of ineffective assistance counsel that worked together to disintegrate Mr. Blocker's defense and deprive him of his constitutional rights, Mr. Blocker's conviction should be reversed and his case should be remanded. Thank you.
Thank you. On behalf of the state.
May it please the court, Brent Cherry for the state. And I'd like to welcome Judge Ayers to the court. Congratulations on your appointment, Judge. As we look at this case, I think it's important first off to recognize some of the basic facts here. This is a murder that was committed in the presence of 3 witnesses. On the evening of this murder, the defendant, the petitioner, came to the home of Katie and Octavia Greer. Also present at the time was a young man, Jerome Nettles, who was Octavia's boyfriend. When the petitioner and his girlfriend, Letitia Bodie, came to the house, it was just a few minutes after they were there. They seemed to be amiable, and there wasn't a lot of conflict in the beginning. But after a few minutes, Ms. Bodie indicated to the residents there that the petitioner had been beating her and that he forced her to come with her. And based on that, they tried to help her get away. In the process, there was an altercation between Jerome Nettles and the petitioner. There was also some conflict between Katie Greer. She tried to step in and get the victim away from the petitioner. And in the end, Octavia was the one who ended up calling 911. The petitioner obviously became enraged with the victim's desire not to go with him, and ended up kicking her, beating her, and then stabbing her to death. When the defense asserts that there wasn't evidence of premeditation here, I think that the facts very simply indicate that there was premeditation, just by the events that happened there in those few minutes, when the petitioner basically chased this woman down, kicked her, beat her, and then stabbed her to death. Also, there was testimony that after he stabbed her, he said words to the effect of, "Okay, bitch, now you can go." So those facts are very compelling when we talk about premeditation, in spite of the evidence that was offered by Mr. Gowan from the medical experts about his ability to premeditate the effects of long-term drug and alcohol use and his low IQ. Quite simply, the jury heard all this evidence, and they determined that there was sufficient evidence for premeditation. Now, when we talk about the truck, what we had at trial was testimony from the owner of the truck that a black man got in his truck and drove it away. And then we have testimony at the scene of the crime, when the petitioner went out, got in a truck that matched the description, and the license plate matched the truck that was stolen. Later, the truck was found in Arkansas. That doesn't really matter very much. We know that the truck was stolen and that the petitioner had it. And really, you don't need a whole lot more than that to establish sufficient evidence of the theft of the truck. When we talk about the guilty plea to the theft of the truck, what Mr. Gowan testified was that he wanted to gain some favor, or he wanted to gain some credibility with the court. He had an uphill battle in this case when you're talking about premeditation. He wasn't going to be able to get past the fact that that the petitioner killed this woman. That was solid and pretty incontrovertible. We had 3 witnesses that were right there. We had the body of the poor victim having been stabbed in the throat and in the face. So when we talk about the theft of the truck, was it a reasonable strategy for Mr. Gowan to basically throw the jury a bone and say, we're taking responsibility for this? And we understand, I don't think he actually said this, but based upon the facts that were presented, the court wasn't going to be able to get around the fact that that the petitioner killed this woman. But what about premeditation? Having tried to get some favor with the court, Mr. Gowan was trying to avoid that first-degree murder conviction by arguing that there wasn't enough for premeditation. So the real question here, though, has to do with, was the defendant, or was the petitioner aware that Mr. Gowan was going to do this? Certainly, he might have done this in a different way. He might have made a full plea beforehand, and that would have avoided this whole issue. But he didn't. He surprised everyone, standing up there at the beginning of trial and entering a plea of guilty to the theft, but not guilty to the first-degree murder. Mr. Gowan testified at the post-conviction that my recollection is that we did discuss it with him. And yes, he did concede that I could be wrong. But Judge Ward also remembered the plea at trial, and this is what he recalled. What happened was the indictment is read, he's sitting in the same chair he's in, and I turned to the defense to say, how does the defendant plead? And the lawyers stand up and say, he pleads not guilty to murder, guilty to the theft. And he sits there with his hands, he remains silent and doesn't say a word. And now he's getting up here and saying his lawyers never discussed this with him. And I've got 2 other lawyers, Ann Benson and Amy Main, about to testify. And quite frankly, if they pled him guilty without prior discussing it with him, they're probably all guilty of violation of the canon of ethics. So I don't believe for 1 minute that he didn't have advance notice of this. Judge Ward had the opportunity, had the advantage over our view of this case, because he was right there. He was able to view the defendant through trial as well as at the post-conviction proceeding. He made a credibility determination and made a factual finding that the petitioner was aware that he had been informed of this. And at that point, we're done. This is a tactical decision that was made, that the defendant, the petitioner, was made aware of this, and we go forward. And the evidence quite obviously does not preponderate against that factual finding of the trial court. Now, in the petitioner's reply brief, he cites Mccoy versus Louisiana, which is a case where a defendant had been charged with 3 first-degree murders and was facing the death penalty. And in that case, trial counsel wanted to plead guilty to these, or rather admit guilt to these murders in an effort to avoid the death penalty. But that case is not similar to this case at all, because in that case, the defendant vociferously, to use the word of the Supreme Court, denied his guilt and adamantly proclaimed his innocence. That's not the case here. We have a case where the court, where Judge Ward viewed this, and he properly determined that the petitioner had been informed, and that Mr. Gowan's efforts to save his client were based in a reasonable strategy. Now, the petitioner has raised other issues regarding the performance of Mr. Gowan at trial, and I'd like to address a couple of those. First of all, the failure to impeach Katie Greer. What we had here, based on the testimony at the post-conviction hearing, is a case where there was a police report, and the police report, of course, is not a statement of the witness, but in the police report there was no mention of Ms. Greer telling the officers what the petitioner said when he stabbed the victim. And Mr. Brown did challenge Ms. Greer at trial with the fact that she didn't make this statement or didn't tell police about it. And she can say, I don't remember if I told them or not. So as much as he could impeach her, he did. He didn't have a statement by Ms. Greer that he could pull out and say, isn't it true that you made this statement shortly after the murder and you said this and this and this, but you didn't say this? He didn't have that. Nothing in the record suggests that was even an option. Mr. Gowan testified that he didn't have a statement to impeach her with, and so that argument pretty much ends there. How do you impeach somebody with a prior statement if there is no prior statement? When we talk about the appeal, Tony Brayton is a pretty well experienced appellate defender, and we've seen many of his briefs in this court. When Mr. Brayton got up to testify at the post-conviction hearing, he testified that he didn't raise this because basically he didn't think it was a good issue. Judge Ward gave this very brief instruction, basically just telling the court that the defendant the petitioner was pleading not guilty to the murder and guilty to the theft, but still charged the jury that they needed to look at the evidence and make a finding of guilt. Judge Ward was acting consistently with the strategy of the defense. Although the strategy was ultimately unsuccessful, again, that does not mean that counsel was ineffective. Mr. Brayton testified that he didn't challenge the instruction because it was accurate and he didn't think it was an issue. And there's nothing that we can really see that Judge Ward told the jury that wasn't accurate. He told them exactly what happened, but he also did tell the jury that they needed to consider the evidence to determine whether the petitioner stole this truck or not. I believe I've covered the issues that have been raised by the petitioner here on appeal today, this morning. They were taken a little bit out of order. I apologize for a little bit of stumbling and getting these out in proper order. But if the court has any questions about any of these issues, I'd be happy to respond to those questions.
All right, sir. Thank you. Rebuttal.
Mr. Cherry, just argued with respect to appellate counsel and the ineffective assistance of appellate counsel that Mr. Brayton is experienced and that he's written many briefs that have come before this court, and that he didn't think that it was a good issue. And yet, nonetheless, this court recognized the jury instructions as an issue and didn't take further action because they weren't appealed. But nonetheless, there was some, strong wording in there, and Judge Ward commented on that several times in the post-conviction hearing. And so, although Mr. Brayton did not consider it an issue, I think that's the point here, is that that was a bad call, and that was a bad call that rises to the level of ineffective assistance of counsel, of appellate counsel in this case. Turning to the strategy of trial counsel to plead guilty to the theft charge. The trial strategy only works if a couple of conditions are met, right? So the first is just very fundamentally that the defendant has to consent to the strategy. And unlike other trial strategies, this particular trial strategy involves a constitutional right of such great importance that absolutely the defendant would have to consent to that, and Mr. Blocker would have had to consent to that in order for the strategy to be a legitimate defense trial strategy, and he didn't. And I think that there's evidence from the post-conviction hearing that supports Mr. Blocker's testimony that he didn't consent. The strategy, also didn't work for all of the reasons that I already spoke about, and it was, it's for all of those reasons that I am respectfully requesting that this court reverse the conviction and remand this case. I'm happy to answer any questions.
Okay, thank you very much. Appreciate
Thank you.
the arguments. If you will, recess the court.
This court is in recess until 1 p.m.
Thank you.
Thank you.